was neither of those situations here. So I was surprised that they were even required to file a motion. They did file a motion. They won on the motion. I thought it was odd that Attorney Busby came out today and said we had tried to talk to them about giving them the names, but we didn't get there because in the filing paperwork, I didn't see anything where they alleged that in court. They only said that in a press statement. So I don't. By Rusty Hardin's position, he said we demanded the names, and they said no, file a motion. So he filed a motion, and he put that in his affidavit in the court papers. So one person saying one thing to the court and one thing, and the same thing to the press. The other saying something to the press and not saying it to the court. And I tend to believe the one who's consistent across both.
It looks like one woman is dropped out for fear of scrutiny. This is kind of what you fear, doesn't it?
This is poor lawyering. That's all. If you have one of these 22 women drop out of the case because they're now going to be made public, you did, I think, a poor job of counseling your client as to what was about to happen. In Nevada, their names would have been kept private if they are a victim or alleged victim of sexual assault. But you can ruin that privilege being able to file under a pseudonym if you do what Busby did here, go out into the public realm, make a bunch of accusations, put on press conferences, say things in addition to the press that you're not saying to the court under the protections of Jane Doe, and the court can and does take away your pseudonym protections, takes away the anonymity that you can file with at that point. So yes, they would have been able to file as Jane Doe's here, but based on the way that they conducted themselves in the press conferences, I think that there is a real risk that they would have lost that privilege.
Ultimately, is this guy turned into a freaking disaster, this Busby guy, the way he's handled it?
We'll see how many of these hold up.
I mean, we still haven't really gotten a look at the proof, and there may be awesome proof on their side.
Maybe if there's awesome proof on their side, I don't know why they wouldn't give that to the police, or at least feign cooperation with the police. But they are doing a real poor job of that. Clearly, if one of the clients dropped out, he either did not properly counsel her, or they made a educated decision, which is, or risk. They took a calculated risk where they said, hey, listen, I know you don't want your name out there. You know you don't want your name out there. We're going to file your claim under Jane Doe. Eventually, the court is going to want me to disclose your name or have the case dismissed. We'll just have the case dismissed at that point. But your part in all of this is going to be another person who tells the story out there so that they know that the numbers are high. And that to you is maybe worth it. If that was the counseling, okay. But I think ethically, you're skirting a really dangerous line there as to whether or not that's okay.
Justin, as someone who is just trying to follow this case in general, we talk a lot about the fact that it's being fought publicly, right? It's being fought in the court of public opinion. And as someone just trying to keep up with it, I'm having a very difficult time. Is that the point? Is that the entire point for at least one of these sides to make it so that it is very difficult to follow this thing?
I don't know. If I had to guess, and it's a complete guess, I don't know this. If I had to guess why it's being presented in the press in the manner in which it's being presented by the plaintiffs, it is a recruiting tool. It is trying to establish enough people who are willing to come forward that if there are anybody else that they feel comfortable coming forward to, and the numbers increase. And largely we've seen that that's been the case because I think the first iteration was 7. And we have continued, then it went to 12, and then it went higher and higher and higher. So I think that that's why they went to the press, because I cannot think of a legally sufficient basis for doing that and how it's going to help you win the case either a great settlement or trial, because the reality is the going to the press is kind of your trump card in your back pocket. It's not something you're supposed to leverage like that, ethically speaking. But in a case like this, if you haven't gone to the press, you know that the defense does not go to the press. That's your potential to try to strike a deal to get the case settled. Here, they tried that. He called their bluff, said, I'm not paying you off. They filed the lawsuit. They could have filed the lawsuit and kept somewhat vague and not gone to the press, and again tried to leverage stories and their numbers to grow and not played that trump card so early. But here they did, and the only thing I can think of as to why they would do it is to recruit more people.
Justin Watkins, legal insider at Battlemore and Injury Lawyers, as we're hanging out at the Battlemore and Broadcast Center. Let's close on this one. A lot of anger last week. Highly debatable topic. We can probably hit on this a little more in our podcast. We do a 9 o'clock podcast live on Thursday nights, Law and Sporter. But I saw a South Carolina rep, Jeff Duncan, came out after Major League Baseball pulled the All-Star game from Georgia, and he's like, that antitrust exemption, it is time to re-examine it. What is it?
So the antitrust exemption prevents me from Congress to determine whether or not baseball has competitive, either anti-competitive or competitive environment to the industry. Meaning, Congress can, from time to time, they've done it recently with Microsoft and Apple. They can look at it and say, "You've got too much power over this industry. You have a monopoly, and therefore we're going to require you to break up." The classic example, every lawyer hears about this when we're learning about it in law school, is the telephone companies. There was Bell, then there's Pacific Bell, then they broke them up numbers of times over and over and over again. So there wasn't just one company being the telephone utility. An antitrust exemption not only does that, but it has tax ramifications too. A large of your expenses can be they're tax write-offs and they're a benefit to you in the tax code that you can lose in the antitrust. Not because antitrust has anything to do with tax, but this particular exemption, the way they codified it, has allowed that.
So what do you think of this political move?
I don't think it's going to go anywhere. Not, at least not currently. While the Democrats are in charge of all three houses. I mean, yes, the Republicans are upset about it, but because the Republicans are upset about it, the Democrats are happy about it, and they're the ones that are currently in power. Where would it have to go to actually mean something? I think the upset party, the aggrieved party, would have to take all three houses. I mean, and that's not going to happen. Well, Biden's in office until 2024. So until at least then.
570-9000 is the number. It's 570-9000. Justin, good job. Appreciate it. 4 o'clock hour is on the way. We'll check in with Caleb Herring on UNLV football and what's on before the draft in 15 minutes.
Call Battleborn Injury Lawyers.
Shut this down.
We made it.